So, in this video, I want us to shift our attention to the doctrine of frustration, the doctrine of breach, and the doctrine of operation of law. Now, the first thing I want us to look at is discharge by impossibility, which is the doctrine of frustration. So, what is the meaning of the doctrine of frustration? You see, a contract is frustrated where after formation, an unforeseen event occurs, making performance impossible, making performance illegal, or making performance commercially useless, without fault that is of either party. Now, the effect of frustration is that the contract automatically ends and parties are discharged. Now, I want us to look at the historical common law position. Now, medieval common law followed the principle of absolute contractual obligation, meaning once you promise, you must perform no matter what. And that means there are no excuses. If you look at the case of Paradigm versus Jen, the facts of this particular case was that the plaintiff leased land to the defendant. Enemy forces invaded and occupied the land, and the defendant could not use the land. So the plaintiff demanded rent, and the issue was whether the defendant was still liable. And the rule is that contractual obligations are absolute unless contract says otherwise. And the application of this particular case was that the lease had no clause excusing performance. And the conclusion of this particular case was that the defendant remained liable. Now, a good example is when you rent a shop and road closure blocks access to your shop. So that if a contract says nothing, old common law is still expected that payment is going to be made. Now, let's look at justification for frustration. Now, the first justification for frustration is the implied term theory. Now, here the law assumes that parties intended discharge if unforeseen event happened. The second justification for frustration is just and reasonable theory, in that fairness requires discharge. The third justification for frustration is disappearance of foundation theory. Here is where you know the basis of the contract actually disappears. The fourth justification for frustration is change of obligation theory, where the contract becomes fundamentally different. Now, let's look at the circumstances that frustrate contracts. Now, the first circumstance that frustrates contract is destruction of the subject matter. And this is where you know the thing contracted for is actually destroyed. If you look at the case of Taylor versus Caldwell, the facts of this particular case were that the plaintiff hired the defendant's hall for concerts. The hall burnt down before event. And the issue was, could hiring charges be recovered? And the rule is that destruction of essential subject matter frustrates the contract. And the application of this particular case was that the hall was the foundation of the contract. And so the conclusion of this case was that the contract, was frustrated, hence there was no payment. So that if, for example, you hire a wedding venue and it burns down before the wedding, then the contract actually ends. The second circumstance that frustrates contracts is non-occurrence of an event. And this is where the contract depends entirely on an event. So that if the event fails, then the contract ends. If you look at the case of Krell versus Henry, the facts of this particular case was that the defendant hired a room to watch coronation procession. Now, the coronation was cancelled. And the issue was payment still due? And the rule is that if the sole purpose fails, then the contract is frustrated. And the application of this particular case was that the coronation was the only reason for hiring that particular room. So that the conclusion of this case was that the contract was frustrated, hence no payment. So that if you rent a balcony to watch a marathon and the marathon is cancelled, then the contract actually ends. It's however important to note that if a contract has multiple purposes, frustration may actually fail. The third circumstance that frustrates contracts is supervening illegality. You see, performance becomes illegal after contract formation. Now, the rule is that law does not compel illegal acts. So that if you contract to import goods and the government later bans those particular goods, then the contract ends. The fourth circumstance that frustrates contracts is death or permanent incapacity. Now, this one applies to personal service contracts. Now, the reason for that is because personal obligations cannot be transferred. So that if a famous singer is booked for a concert and the singer dies, then the contract ends. The fifth circumstance that frustrates contracts is government intervention. And this is where government action makes performance impossible. If you look at the case of Karachi Gas Company versus Isaac, the facts of this particular case were that government refused export license. And so the defendant claimed frustration. And the issue was, did refusal frustrate the contract? And the rule is that government refusal frustrates only if the license was the foundation. And the application of this particular case was that the contract was for export, not for obtaining a license. Now, the conclusion of this particular case was that there was no frustration, hence liability remained. So that if you promise to sell sugar and the government delays permit, but alternative lawful means exist, then there is no frustration. If you look at the case of Metropolitan Water Board versus Dick Care and Company, the facts of this particular case was that company contracted, to build a dam, and government ordered stoppage, and so the work stopped. And the issue was whether the government order frustrated that contract. And the rule is that government intervention making performance impossible frustrates a contract. And the application of this case was that the work was legally stopped. So that the conclusion of this particular case was that the contract was actually frustrated. So that if the government compulsorily acquires land under sale agreement, then the sale ends. The sixth circumstance that frustrates contracts is supervening events. In that unexpected events, fundamentally, alter performance. Now, the rule is that extra expense alone is not frustration. It must change, commercial purpose. If you look at the case of Sagirogo and Company Limited versus Noble Thor, the facts of this particular case were that groundnuts were to be shipped through the Suez Canal. Then the canal closed and alternative route existed, but the route was costly. And so the issue was, did extra expense frustrate the contract? And the rule is that mere increased cost does not frustrate the contract. And so the application of this particular case was that an alternative route existed and goods remained, usable. So the conclusion of this particular case was that there was no frustration, hence the supplier was held liable. So that if fuel prices rise during delivery, then the fuel becomes more expensive, but it is still possible, hence there is no frustration. If you look at the case of Victoria Industries Limited versus Brothers, the facts of this particular case were that maize transport depended on railway. Now, the railway declined transport, but there was no alternative route. So the issue was the contract frustrated? And the rule is that if no alternative means exist, then frustration applies. And the application of this particular case was that the transport became impossible. So that the conclusion of this case was that the contract was actually frustrated. So that if the only bridge to deliver goods collapses, then there is no alternative road, and the contract actually ends. Now, let's look at when frustration does not apply. Now, the first situation when frustration does not apply is self-induced frustration. You see, self-induced frustration is where one party caused the event, so that destroying your own warehouse, then claiming frustration, is not legally allowed. The second situation where frustration does not apply is when you have a situation of force majeure clause that exist. You see, force majeure clause is where a contract already provides for such an event. So that if a contract says floods will suspend obligation, then uses the clause, then there is no frustration. Now, let's look at the effects of frustration in Kenya. Governed by the Law Reform Frustrated Contracts Act 1943, the effects of frustration include number one, contracts terminate, and this is when a contract, ends automatically. Governed by the Law Reform Act 1943, the effects of frustration of a contract include number two, money paid is recoverable, so that advance payments can actually be reclaimed. Governed by the Law Reform Act 1943, the effects of frustration of a contract include number three, money payable stops being payable, so that future payment obligation cease. Governed by the Law Reform Act 1943, the effect of frustration of a contract include number four, compensation for expenses, so that court may reimburse, the performing party. Governed by the Law Reform Act 1943, the effects of frustration include number five, compensation for benefits received, so that court may award reasonable compensation. Now, let's look at discharge by breach of contract. Now, this is where, a party fails to perform contractual obligation, so that breach gives the innocent party options, but it does not automatically discharge the contract. Now, the types of discharge by breach of contract include the following. The first type of discharge by breach of contract is anticipatory breach. Now, this one occurs before due date, so that one party clearly indicates intention not to perform. Now, the remedies for anticipatory breach include number one, you sue for damages. If you look at the case of Frost versus Knight, the facts of this particular case was that the defendant promised marriage after the father's death. She married another person before then, and the issue was whether anticipatory breach was there. And the rule is that there must be clear intention not to perform, so that it can actually amount to a breach. And the application of this particular case was that marriage to another made the performance impossible. Hence, damages were actually awarded. So that if you order a car and the seller tells you before delivery that he sold the car elsewhere, then you should sue immediately. The remedies for anticipatory breach include number two, wait for performance, in that the innocent party may actually wait. Now, the risk is that the contract may be frustrated later, and then the remedies disappears. If you look at the case of Avery versus Boyden, the facts of this particular case were that one party delayed suing, war broke out and frustrated the contract, and the rule was that waiting can actually destroy remedies. The conclusion of this particular case was that there were no damages. So that if a supplier says he won't deliver, you wait. If the government bans good, you lose the remedy. The remedies for anticipatory breach include number three, specific performance. And this is where the court orders actual performance, usually for unique subject matter. If you look at the case of Hasham Jiwa versus Zenad, the facts of this particular case was that the land seller refused completion. And so the buyer sued, and the issue was, could court compel sell? And the rule is that specific performance is available where damages are inadequate. And the application of this particular case was that land is actually unique. So the conclusion of this case is that the court ordered performance, so that if a seller refuses to transfer land after payment, then the court can actually force a transfer. An important rule to remember is that in anticipatory breach, the innocent party is not bound to mitigate immediately. The second type of discharge by breach of contract is actual breach, and this occurs on due date where a party fails to perform or performs defectively. Now, the consequences depend on type of term breached, so that if there is breach of condition and there is a serious term, then it allows for repudiation. If you look at the case of Paulsad versus Pierce and Pond, the facts of this particular case were that a leader performer missed opening performances. And so the issue was this fundamental breach. And the rule is that breach of condition allows for termination. And the application of this particular case was that opening performance was actually essential. So that the conclusion of this case was that the contract was repudiated. So that if wedding photographer fails to appear on wedding day, then that amounts to fundamental breach. If there is a breach of warranty and there is a minor term, then only damages are available and there is no termination. So that if a wedding cake is delivered slightly smaller than agreed, then that is a minor breach, so that you sue for damages only. Now, let's look at discharge by operation of law. You see, a contract ends because the law says so, not because parties choose. The circumstances for discharge by operation of law include, number one, a merger. So that if a simple contract is merged into a formal written agreement, then the old contract disappears. So that if oral land sale is later formalized into written agreement, then the oral agreement merges. The circumstances for discharge by operation of law include, number two, death, and this applies to personal service contracts. So that if a personal tutor dies, then the contract ends. The circumstance for discharge by operation of law include, number three, lapse of time. And this is failure to act within required time. In that time, bars enforcement. So that if a contract requires payment by Friday and the payment is not made, then the contract may end. So here is a quick summary of what we've covered so far. For frustration, remember DNIDGS: destruction, non-occurrence, illegality, death, government intervention, and supervening event. For breach, remember AA: anticipatory and actual. For operation of law, remember MDL: merger, death, and lapse of time. The golden rule is that you must ask, did performance become impossible, which is frustration? Secondly, did one party refuse to perform, which is breach? And thirdly, did law intervene, which is operation of law? My name is Biket. If it is your first time here, make sure to subscribe and to follow this channel for more legal lessons.